Greetings and welcome to Summary Judgment, Part 9, What Constitutes a Genuine Issue of Material Fact. Before we get started, greetings and welcome to everybody. And just a reminder, this is strictly for the entertainment educational purposes of this YouTube channel and broadcast, not to be used, misconstrued, or abused for anything legal, lawful, personal, private, business, tax, financial, or otherwise, so please don't do this at home. That said, let's get started. We left off last time on section 46, and we're on to the facts that support more than one inference. So as I mentioned before, since we're doing summary judgment here, the nature of summary judgment is that the cases don't go to trial if it's granted, and even if it's not granted, we're only concerned with the portion that was taken on appeal about the summary judgment, and that's what we're covering here. So we get to review a case in its entirety. That's going to be very brief. It's going to give us a full overview of the topic and the subject matter we're discussing, and also give us practice at the way we dissect and analyze cases. So this is a good practice to get a large volume of cases, a lot of exercise and experience doing this, which then you can later apply to the larger, more complex and time-consuming cases. That said, let's get started. When facts support multiple plausible inferences on, just got the notification, so I hope everyone is arriving. All right, no demerits for any tardiness or anything like that, since I guess the notifications were late, but better late than never. That said, let's continue here. Okay. So when facts support multiple plausible inferences from facts on pivotal issues, the courts cannot choose between them, precluding summary judgment, especially when credibility or subjective intent is involved, which would be, of course, for a jury. So when we have facts that support multiple plausible inferences, all right, so this takes away any kind of discretion from the court. Courts cannot choose between conflicting inferences when facts support more than one plausible conclusion. Key. So if there's more than one plausible conclusion, then the courts cannot choose. That means there's no discretion. Summary judgment is inappropriate when evidence is susceptible to different interpretations. So this is the important part here. The evidence is susceptible to different interpretations. Even if there's so this is where the evidence, even if presented from both sides, it's different interpretations. Disputing legal conclusions from undisputed facts does not bar summary judgment, though. So the legal conclusion is a matter of law, right? Is the only thing left for the summary judgment. So disputing legal conclusions from undisputed facts does not bar the summary judgment. So it's not about the legal conclusions, it's about the facts, the undisputed facts, or if there is dispute among the facts. When court is trier of fact, as in a directed verdict here, summary judgment is appropriate if material facts are undisputed. So all the evidence would support a directed verdict.
Bill Limit 4426 says, I would guess that if all the interpretations still pointed to one side, it might allow summary judgment.
If all the interpretations, well, it's a matter of the interpretations would be for one side or the other, though. So I guess that's kind of it'd be a little confusing there. One side's, if there's cross motions, or if one side is just opposing the summary judgment, then there would be different ways of interpreting those facts. The point of being is that if there is a reason, if there's no cross motion for summary judgment, if there's just a dispute amongst the facts, then that would preclude the summary judgment. But if there's as you're saying here, if it's just about the interpretations disputing the legal conclusions from undisputed facts, does not bar the summary judgment. So if it's just about the interpretations or disputing the legal conclusions, the point being is that undisputed facts would allow it to be considered for summary judgment. But if the facts are disputed in any way, as we say here, even if there's more than one plausible conclusion that can be drawn from facts, then it does that would be one where the courts can't choose between the two. This doesn't say whether they can or not grant summary judgment, just says which ones they can't choose. And of course, the summary judgment is inappropriate when the evidence is susceptible to different interpretations. So I guess in that one there, if all the interpretations still point to one side, it might allow. Summary judgment is inappropriate, though, when it's susceptible to different interpretations. And it could be appropriate when they have the same interpretations, but then there wouldn't be a dispute. All right. I think I get it there. I hope you do. But we're going to move along here. Oh, wait. We have one more here. The court alone. Oh, got a little away from us here. There we go. The court alone is responsible for resolving conflicts between inferences in non-jury trials. So if it's a non-jury trial, the court alone is responsible for resolving conflicts between inferences. So again, if there's different interpretations here, then the court alone is responsible for resolving those conflicts if it's a non-jury trial. And of course, it's inappropriate when evidence is susceptible to different interpretations. So you see a lot of complexity there when we start to dig in deeper. And let's continue here with some cases for the facts that support more than one inference. So here's the improper inference in summary judgment motion. District court's inference that corporation drafted separation agreement in response to discovering affidavit was improper, as court must make all reasonable inferences in favor of non-movement when ruling on summary judgment motion. So the district court's inference that the corporation drafted separated in response to discovering was improper. It was in response to discovering affidavit was improper. The way they write these sentences here, there's a lot of synecdoches and such, so we have to really break it down. So let's read this through one more time and make sure we have it clean. District court's inference that the corporation drafted a separation agreement in response to discovering the affidavit was improper. So the district court's inference was improper. The inference that the corporation drafted an agreement in response, okay, because the court must make all reasonable inferences in favor of the non-movement. Oh, okay, good. That's Cooper Tire and Rubber versus Farsi, 5th Circuit, 2005. Excellent. So that makes perfect sense there from what we've read before. Conjecture and speculation in summary judgment. Inferences supported by conjecture or speculation will not defeat a motion for summary judgment. Evidence must be more than mere speculation to create genuine issues of material fact. Can anyone think of another word that starts with S other than mere speculation? The evidence must be more than mere speculation to create genuine issues of material fact. Put it in the chat for if you can think about it for extra credit. Starts with an S. Would fit right in there other than speculation. And that's this.
4426 says scintilla.
Excellent. The scintilla. More than a mere scintilla is required. Excellent. All right, and that's from Self versus Crum. Petition for certiorari filed, and that was in 2006. Wow, okay. All right, now we're on to section 47. What constitutes a genuine issue? So we're looking for a genuine issue of material fact, but what constitutes a genuine issue. A genuine issue of material fact requires substantial evidence that a reasonable jury could resolve in favor of the non-moving party with real basis in the record, rather than formal or shadowy claims. So a genuine issue of material fact requires substantial evidence that a reasonable jury could resolve in favor of the non-moving party with real basis in the record, rather than formal or shadowy claims. Wow, in favor of the non-moving. So a genuine issue defined as triable, substantial, or real issue of fact that can be maintained by substantial evidence. Evidence must be such that a reasonable jury could resolve the fact in the manner urged by the non-moving party. So remember, being, given all favor or benefit to the non-moving party here in gauging this evidence. The court must search the proof to determine if it discloses a real issue rather than a formal or shadowy one. And we're on to the evidence too incredible to be accepted by reasonable minds does not raise genuine issue of fact. So yeah, the aliens abducted you and took you away or something like that. It's too incredible to be accepted by reasonable minds. And then the court must be convinced the issue is not genuine, but feigned to justify awarding summary judgment. Wow, so this is what constitutes. It must be, and to think if it's a feign to justify awarding, it must be convinced that the issue is not genuine. So here's how we get the genuine issue. It can't be incredible. It can't be feigned to justify awarding the summary judgment. It must be triable, substantial, or real, something that could be resolved in the manner urged by the non-moving party, and we should still be able to be in the moving party's favor if it's in fact true. All right, let's check out some cases here on Section 47, what constitutes a genuine issue. Here we have debt collection activity under the FDCPA, under the Fair Debt Collection Practices Act, right? Genuine issue material fact existed as to whether law firm regularly engaged in debt collection activity to qualify as debt collector under the FDCPA, precluding summary judgment. So there's genuine whether they regularly engage in debt collection activity. So how could they be under that if they're not true debt collectors under that definition? That's Goldstein versus Hutton, Ingram, Usick, Gainan, Carroll, and Bertolotti, 2004. Now next one is flashbang device used by police. Genuine issue material fact as to whether police officers threw flashbang device directly at apartment occupants, violating Fourth Amendment, precluding summary judgment on Section 1983 claim. Really, yeah, I guess it's someone threw a flashbang. I think it would be pretty clear, but I guess they claim there's a issue of fact here. That's Taylor versus City of Middleton in Connecticut, 2006. Now we're on to constructive total loss of vessel. So now we get some admiralty stuff here. Valuation expert's statement in affidavit that vessel was not constructive total loss did not create genuine issue of material fact where it directly contradicted expert's deposition testimony. Valuation, wow. Expert statement in affidavit that vessel was not constructive total loss did not create genuine issue material fact where it directly contradicted expert's deposition testimony. Wow. Now I'm trying to figure out why that would happen there. See here. Expert statement in affidavit. Okay. Was not constructive did not create a genuine. Okay, so his statement alone didn't create a genuine issue. So let's get back here to see what exactly, where would that fit in here? Oh, his statement. Is it trial, substantial, real? Yeah, I guess proof or a formal. Okay, yeah. So that's where it fits in here. I get it. So the valuation expert statement in the affidavit, even though it's in an affidavit, his evaluation expert statement, just saying it was not, and we had experts. Unless it's the same expert, and he contradicted his own testimony. Okay, either way, that's from Maine 2004. That's Sailor Incorporated versus City of Rockland. Oh, nice, in the coast of Maine. I think that's where Andre the Seal. No, it's Rockport, a little north of Rockland, but still there. They call down east. They're Kennebunkport, where one of our presidents hails from, former presidents. Let's continue here. All right, excessive force and qualified immunity. Genuine issues of material fact existed as to whether claim victim possessed knife, held blade up down, walking aggressively, waving arms, and made threatening gestures, precluding summary judgment on excessive force claims. Okay, yeah, it sounds like a lot there. Murphy versus Bitosi, 2004. Vagueness of attorney, specialization rule. Genuine issues of material fact existed as to whether New York State disciplinary rule governing attorney statements as to specialization was unconstitutionally vague as to disclaimer requirement. Okay, yeah, genuine issues is whether they're vague. That's for the jury, and that's Hayes versus Zakia, New York 2004. Now we have feed quality and misrepresentation claims. Genuine issue of fact existed as to whether feed company statements regarding quality of dairy feed pellets and diagnosis of herds' ills were based on sufficient evidence, precluding summary judgment on misrepresentation claims. Yikes. That's Doe versus Southwest Grain. That's 2004. Now we have a mere disagreement isn't sufficient for summary judgment. We've read this before. The mere disagreement or bald assertion. What's a bald assertion? Bald is usually means with no detail, just a general, all-encompassing assertion that a genuine issue of material fact exists no longer precludes the use of summary judgment. Evidence must be more than mere disagreement. And that's from Hutzinger versus Shaw Group, 2006. ISP, good faith defense to ECPA violation. Electronic Communications Privacy Act, I think. Genuine issue of fact existed as to objective reasonableness. This is a great term here. Objective reasonableness. Genuine issue of fact existed as to objective reasonableness of ISP employees' belief that warrant was valid. Objective reasonableness that he believed on his belief that it was valid. And that precludes a summary judgment on the ISP's good faith defense to ECPA violation. So yeah, genuine issue fact. That's Friedman versus America Online, 2004. And here's back to our favorite word of the day. More than a scintilla of evidence required. A genuine issue of material fact exists, precluding no evidence summary judgment if non-movement produces more than a scintilla of evidence establishing existence of challenged element. That's from Fort Worth Osteopathic Hospital versus Reese, Texas 2004. More than a scintilla of evidence is required. All right, and that takes us on to Section 48. What constitutes a material issue? So we had what constitutes the issue of fact, right? Let's see here. What constitutes a genuine issue? And now we get what constitutes a material issue. For summary judgment purposes, a material fact is one that has the potential to alter the outcome of the suit under the governing law if resolved in favor of the non-movement. Material facts have potential to alter the case outcome under governing law. Material facts tend to prove or disprove elements of disputed claims. So remember, the material facts affect the outcome. Determination of materiality guided by substantive evidentiary standards. The court views evidence through prism of controlling legal standard.
Bill Finish 4426 says, I remember quiz questions I get wrong more than ones I get correct. The subject feels like it comes up more often when I misunderstand.
Yeah, this is some tricky stuff here, I'll tell you that. I'm not going to say that, the thing is that this was the old style for law school, was going through the American jurisprudence. It was like the encyclopedia. It seems like there's a different approach these days. However, it's still, this is the backbone of our common law still. And even with the intersection of the statutory and other codes and such, it still behooves us to learn how the backbone, the foundations of our law really functioned, and at least where they should be or where they've gone a little astray, but in all ways just to kind of keep things on course, because things could be a lot worse. That said, let's move along here. So on Section 48, we're going to look at what's a material issue. Now remember, it's something central to the case. It could affect the outcome, and material facts have the potential to alter the case outcome under the governing law. So there's a tie in between those material facts and the governing law. Material facts tend to prove or disprove elements of the disputed claim. So the material facts are also tied to the claims. Determination of materiality is guided by substantive evidentiary standards. So determining whether the facts are material or not are guided by the evidentiary standards regarding the venue, of course, jurisdiction. Court views evidence through prism of controlling legal standard, and the summary judgment is appropriate if only suggested issues of fact are immaterial. So if it's just suggested issues of fact, not material issues, there's a new term there, suggested issues of fact are immaterial. So then summary judgment is appropriate. No dispute on suggested facts. So let's look at some of these cases here. Jewelry importers, sales classification. Issue of material fact as to whether jewelry importers, quote unquote, purchases from related supplier were bona fide sales or merely consignment sales. Precluded summary judgment on customs use of computed value to calculate duty. Oh, geez. That's from Am Jur, International Trade, 2004. Landfill compliance with federal regulations. So, yeah, I think this was the Court of International Trade, 2004. I wonder where this was. Is that the one in the Virgin Islands or something? And this is Am Jur. So probably something from East Asia. All right, we're on to landfill compliance with federal regulations. Material issues of fact existed as to whether county operating solid waste landfill complied with the federal regulation requiring application of cover over waste at the end of each operating day. precluding summary judgment on RCPA claims. So whether they complied or not was a question. So there's no summary judgment on that. Covington versus Jefferson County, Ninth Circuit, 2004. Then we have patent infringement under doctrine of equivalence. So this is issue of material fact as to whether accused golf grip, which spirally wound textile strip around rubber sleeve, materially differed from patent claim, calling for attachment directly to club shaft, precluding summary judgment. Yeah, the nitty-gritties for the jury, isn't it? These patent infringement ones are for the juries for sure. That's Wynn Incorporated versus Eaton Corp. And that's California, 2003. I wonder if Wynn won. All right. Here's another patent prosecution latches claim. So time expiring with latches. Material issues of fact existed as to whether patent holder withdrew applications prior to issuance out of concern that patent would issue in unsatisfactory form, precluding summary judgment on latches claim based on 15-year patent process. Wow. That's Rifen versus Microsoft, California, 2003. All right. Now we're on to the police training and shooting liability. Material issues of fact existed as to whether city incorrectly trained police officer conducting automobile stop to rush vehicle with drawn gun, precluding summary judgment on city's liability for shooting of driver. Jeez, in Section 1983 action. And that's from Parker versus Town of Swansea, Massachusetts, 2003. So here's we don't really know. That's a question for the jury. Was he incorrectly trained, or did they train him to do that? All right. Now we're on to excessive force and qualified immunity. This is from the same case. Material issues of fact existed at, so there's a few of them, whether the driver exiting the automobile after a high-speed chase posed threat, and whether officers could reasonably believe firing 49 shots was necessary, precluding summary judgment on qualified immunity claim. 49 was necessary, or 48, 50, does it matter? Geez, 49 shots. So material issues of fact existed as to whether the driver exiting the automobile after a high-speed chase posed a threat. And here's the other issue of fact, whether officers could reasonably believe firing 49 shots was necessary. Definitely for the jury on that one. Precluding summary judgment on qualified immunity claim. And we have satellite signal interception claims. Material issues of fact existed as to whether buyer of signal theft device intercepted satellite broadcasts, precluding summary judgment on distributors' claims for unlawful interception under federal statutes and conversion under state law. That's from DirecTV Incorporated versus Kavanaugh in Michigan, 2003. So someone was stealing direct, and they had there's genuine issues of material fact, whether he's actually receiving those signals, or whether he intercepted them just because he had the device. Now we're on to the foster children emergency removal. Yikes. Genuine issue of material fact existed as to whether agency representatives had objectively reasonable basis for concluding foster children were in imminent danger at the time of emergency removal without hearing, precluding summary judgment on due process claim. Wow, that's dirty. Johnson versus City of New York, 2003. All right. And we're on to the stockbroker fraud claims. Material issue of fact as to whether stockbroker made promises to trustee to liquidate equity holdings while secretly intending not to do so, precluding summary judgment on trustees' fraud claim under Oregon law. Wow. So they don't know if he actually made the promises. That's the Thorpe Family Charitable Remainder Uni Trust versus Federico in 2004 in Oregon. Material fact definition. Here we go. We were talking about issue of material fact. Well, here's our definition. We got a good case here, and this is look, Santiago Rivera versus Johnson & Johnson in Puerto Rico, 2006. Fact is material for summary judgment purposes if, based on substantive law at issue, it might affect the outcome of the case. It might affect the outcome of the case. Material facts must be determined by reference to substantive law. So remember, it has to have that connection to the law, the governing law, as we heard before. Here they say reference to substantive law, which is probably more general. So fact is material for summary judgment purposes if, based on the substantive law at issue, tying into the claim, it might affect the outcome of the case. It might affect the outcome of the case. Material facts must be determined by reference to substantive law. All right, then we get the evidence standard for summary judgment. When determining if more than a scintilla, so someone's asking how much is a scintilla? Is it 10, 20, 1/10? When determining if more than a scintilla of evidence has been produced in response to no evidence motion for summary judgment, evidence must be viewed in light most favorable to the non-movement. Jeez. So I guess the scintilla depends on whether you're the moving party or the non-moving party. And that comes from Ford Motor Company versus Ridgeway. And that's where we get that scintilla from. They must have got tired of hearing that word during those deliberations there for whatever it was. Nonetheless. All right. Well, that takes us to the best part. For those of you that stuck around, we get to do the summary judgment quiz and test your knowledge and have some fun. So here's how this works. You put in the chat the number of the question you're answering and a letter you choose. So if I was for question 1, I was going to choose D. I put 1D in the chat, and then we go on to the next question, etc. But take your time. I'm going to read through the questions and answers and pipe it in there anytime you like. So for question 1, when is summary judgment precluded if facts support more than one inference? When is it precluded? When is it made impossible? When is summary judgment precluded if facts support more than one inference? A, when issue turns on credibility or subjective intent. B, when non-movement disputes legal conclusions. C, when trial court will be trier of fact. Or D, when material facts are undisputed. So when is summary judgment precluded if you have facts supporting more than one inference? So A, when the issue turns on credibility or subjective intent.
Ultimate 4426 says 1A.
1A? All right. So you choose 1A when the issue turns on credibility or subjective intent. Remember, more than one inference. When movement disputes the legal conclusions. When the trial court will be trier of fact. Or when material facts are undisputed. So there we go. Let's move along. Question 2. What constitutes a genuine issue for purposes of summary judgment?
Craig Curry G5E says 1D.
All right. Craig Carey picks 1D when material facts are undisputed. All right. So if there's no disputed material facts, then it's just a matter of law for summary judgment. So we're talking about when summary judgment is precluded if facts support. When is summary judgment precluded if facts support more than one inference? And you're saying when the material facts are undisputed. All right, good. So let's move on. Here's question 2. What constitutes a genuine issue for purposes of summary judgment? Genuine issue. Any factual dispute, regardless of evidence. A. B. A triable, substantial, or real issue, or genuine. C. Only issues supported by expert testimony. Or D. Issues maintained by conjecture or speculation. Question 2 should be pretty easy here. Either A. Any factual dispute, regardless of evidence. B. A triable, substantial, or real issue. C. Only issues supported by...
Limit 4426 says 2B.
2B. Very good. We'll stick with that one for now. As you can see, 2B. Okay, let's see here. So we're on to question 3. What makes a fact material for purposes of summary judgment? So what makes it material? A. Any fact mentioned in pleadings. B. A fact that could alter the outcome under governing law. C. Fact supported by expert testimony. Or D. Fact not disputed by either party. So we have, this is another easy one here because we just went over the material. What makes a fact material? Is it A, any fact mentioned in the pleadings, the original action or the claims, the issue? B, fact that could alter the outcome under governing law. C, fact supported by expert testimony. Or D, fact not disputed by either party.
Limit 4426 says 3B.
All right, 3B. Any other takers for question 3? We're going to move on to question 4. All right, question 4. According to judicial precedent, what evidence is insufficient to create a genuine issue of material fact? So according to judicial precedent, so we're looking at some of these cases we read, what evidence is insufficient to create a genuine issue of material fact? A, more than a scintilla of evidence. B, substantial evidence from affidavits. C, conjecture or speculation. Or D, deposition testimony. Now think about this clearly here. According to the precedent, what evidence is insufficient to create the genuine issue of material fact? Now, is it A?
Limit 4426 says 4C.
4C, conjecture or speculation. All right, any other takers? Going once, going twice. All right, we're going to move on to the answers now. And here we go. So for question 1, when is summary judgment precluded if facts support more than one inference? A, when the issue turns on credibility or subjective intent. Like we saw in section 46, it states that summary judgment is precluded when facts support multiple inferences, particularly when issues depend on credibility or subjective feelings or intent, which of course is for the jury. So precludes summary judgment. I think Bill got that one correct. I gave the C off of here. So indeed, let's continue. Question 2, what constitutes a genuine issue for purposes of summary judgment? And the correct answer for 2 is B, a triable, substantial, or real issue of fact. And that was from section 47. It defines a genuine issue as one that can be maintained by substantial evidence, as described as triable, substantial, or real. All right, excellent. Let's move to question 3. What makes a fact material for purposes of summary judgment? And of course the answer was B, a fact that could alter the outcome under governing law. Very succinct, that's exactly what makes it material. It affects or could alter the outcome, and of course only under governing law. And as from 48, Section 48 defines material as having the potential to alter the outcome of the suit under the governing law if resolved in favor of the non-movement. And finally, question 4. According to judicial precedent, what evidence is insufficient to create a genuine issue of material fact? And of course, that's conjecture or speculation, because Section 47, of course, said the supplement states that inferences supported by conjecture or speculation will not defeat a motion by summary judgment. Of course, that was Self versus Crum. And as you see there, more than a scintilla is enough. But with just conjecture or speculation, that would almost be a scintilla of evidence at best. All right. Thank you all for participating. Bill got the A on this one for sure, and the extra credit with the word scintilla, which will be the word of the day here. And thank you all for coming here and attending this. We're almost done with the entire volume of summary judgment. I've been trying to keep these a little bit shorter to make them a little bit more digestible. So we have just, I think, maybe 1 or 2 more to go. It's going to be a short run, and then we'll have digested the entire or ingested the entire volume of summary judgment from the 2008 supplement of American Jurisprudence. So thank you all for being here and participating, and I hope to see you all on the next one. Peace out.
Bill Themis 4426 says, the information I learned here has already been useful for me out in the wild recently. The tribe says, Bill gets that. Bill Themis 4426 says, take care all.